There's a legal mechanism most people will never see. It operates in the shadows of international treaties, hidden in bureaucratic language that deliberately obscures its power. And when it breaks, entire cases collapse before they ever reach a courtroom. At 2:47 in the morning, a single social media post threatened to fracture this mechanism, not through legislation, not through executive order, through something far more effective: institutional fear. What happened in the next 72 hours reveals something uncomfortable about modern justice systems. They don't just depend on laws, they depend on cooperation, and cooperation can be weaponized. Let me show you how the machinery actually works, because once you understand it, you'll see why prosecutors are quietly panicking. Here's what they don't teach in law school. Modern prosecution requires something called mutual legal assistance treaties. Sounds bureaucratic, sounds boring. It's neither. These treaties allow prosecutors to reach across borders and grab evidence: bank records in Frankfurt, property valuations in Edinburgh, financial flows through Dubai. Without these treaties, international evidence simply doesn't exist in legal terms. It's physically there, but legally invisible. The United States has mutual legal assistance treaties with 67 countries. That network took 40 years to build. It processes roughly 3,000 formal evidence requests annually. Each request follows a specific diplomatic protocol that hasn't meaningfully changed since the 1980s. Here's the uncomfortable part. These treaties aren't automatic. They're reciprocal. They require trust. And trust operates on an entirely different timeline than law. When a prosecutor in Manhattan needs Deutsche Bank records, they don't just subpoena them. They file a request with the Department of Justice. The DOJ routes it to the State Department. The State Department transmits it through diplomatic channels to German federal prosecutors. German prosecutors evaluate whether the request meets their legal standards. Then, if approved, they compel Deutsche Bank to comply. That process takes an average of 11 months for a single bank, for a single set of records. Now imagine that relationship becomes conditional. On January 23rd, within 6 hours of a 2:47 a.m. social media post threatening NATO funding, 3 institutional dominoes fell in sequence. First, the European Central Bank's Emergency Committee convened an unscheduled session. Emergency sessions don't happen for political rhetoric. They happen when systemic stability is questioned. Second, Lloyds of London suspended new sovereign debt insurance for 12 European nations. That's a $4.2 trillion market that froze not over economic data, but over a perceived security threat. Insurance markets don't react to tweets unless they're pricing in actual risk. Third, a dormant constitutional case in Germany's highest court suddenly got oral arguments scheduled. A case about military spending frameworks that had been sitting idle for 8 months. Constitutional courts don't fast-track cases based on social media noise. They respond to institutional pressure. That's not random chaos, that's coordinated institutional reaction, and it reveals something crucial about how modern power actually operates. The system didn't break because of what was said. It fractured because institutions calculated their exposure and started protecting themselves. Here's where the structural vulnerability becomes clear. A defendant in federal investigations just demonstrated the capacity to threaten the cooperative framework that enables those investigations, not through legal motions, not through courtroom tactics, through foreign policy leverage. Think about the math. The January 6th investigations are stalled, but financial fraud cases in New York continue. Document retention cases move forward. Obstruction inquiries grind through discovery. Every single one requires international evidence. Deutsche Bank records, Scottish property valuations, Middle Eastern financial flows. The DOJ doesn't just request this information, they depend on it. And they depend on relationships that take decades to build and moments to damage. A prosecutor's entire case can collapse if foreign institutions slow-walk cooperation by just 6 months. Statutes of limitations expire, witnesses relocate, financial trails go cold. It's not dramatic, it's bureaucratic suffocation. Now consider what happens when a defendant can influence that timeline. In 2016, federal prosecutors built a case against a Ukrainian oligarch named Dmytro Firkash. The case required evidence from Austria, Cyprus, and the United Kingdom. Seems straightforward. 3 allied nations, long-standing legal cooperation. It took 4 years to assemble that evidence, not because the evidence was hidden, not because the legal theories were complex, because international legal assistance operates at diplomatic speed, and diplomatic speed is deliberately slow. When Austria delayed processing one request by 5 months, the entire timeline shifted. When Cyprus required additional certifications, another 6 months disappeared. These weren't hostile acts. This was normal process. The case eventually moved forward, but it required constant diplomatic maintenance, prosecutor visits to foreign capitals, State Department interventions, treaties that needed to be honored because both sides benefited from honoring them. Now, apply that fragility to a defendant who can question whether those treaties still benefit both sides. On January 25th, 48 hours after the initial post, the Netherlands Ministry of Justice announced a comprehensive review of all pending U.S. legal assistance requests. That's not standard procedure, that's a diplomatic warning shot. The Netherlands processes thousands of U.S. subpoenas annually. They house the International Criminal Court. They're a cornerstone of transatlantic legal infrastructure. When they announce a comprehensive review, prosecutors understand the subtext immediately. We're reconsidering cooperation. Then, France's finance minister gave an interview that every federal prosecutor should have memorized. He said France would continue to honor treaties with partners who honor their commitments. Not an aggressive statement, a conditional one. That's a renegotiation happening in real time, not through formal channels, through carefully worded public statements that signal institutional recalculation. Germany's Federal Intelligence Service leaked that they're re-evaluating intelligence sharing protocols with nations that demonstrate unreliable alliance commitments. That's targeting data, financial intelligence, the evidentiary backbone of transnational fraud investigations. These aren't emotional reactions. These are bureaucratic entities protecting their institutional interests. And when bureaucracies start protecting themselves, cooperation becomes transactional. The DOJ operates under a principle: no one is above the law. That's not a slogan. It's the institutional foundation that justifies prosecutorial power. But here's the structural problem that nobody has solved. What happens when a defendant controls the diplomatic levers that enable evidence gathering? What happens when the target of an investigation can threaten the cooperative framework itself? The Constitution doesn't address this. Federal rules of criminal procedure don't address this. It's a gap between law and power that becomes visible only when someone with sufficient leverage decides to exploit it. If you or I faced federal charges and threatened institutions holding evidence against us, prosecutors would file emergency motions immediately. Witness tampering, obstruction of justice, abuse of process. The charges would multiply faster than we could comprehend. But when the threat operates through foreign policy channels, when it's executed through social media platforms, when it targets international relationships rather than domestic witnesses, the legal framework becomes suddenly unclear. Judges can issue subpoenas, they can compel testimony, they can sanction obstruction with contempt charges that carry real consequences. But their domain ends at the border, and modern prosecution requires reaching across that border constantly. A judge can order a defendant to produce documents, but if those documents are held by a foreign bank under foreign law, the judge's order is meaningless without international cooperation. They can hold the defendant in contempt, but that doesn't produce the documents. The evidence either exists within reach of U.S. legal process, or it doesn't. And increasingly, for complex financial cases, it doesn't. That's not a bug in the system, that's a feature. Transnational crime requires transnational prosecution, which requires transnational cooperation, which requires relationships that take decades to build and moments to damage. The judiciary wasn't designed for a scenario where defendants can control the diplomatic levers that enable evidence gathering. That power was supposed to remain separate, foreign policy in one sphere, criminal prosecution in another.
The spheres just merged, and nobody knows what legal framework applies when they do. Here's the uncomfortable truth at the center of this entire mechanism. The American legal system's ability to hold powerful people accountable depends entirely on whether foreign allies choose to honor that accountability. That's not a legal system, that's a diplomatic arrangement, and diplomatic arrangements are always conditional. France will cooperate if the U.S. honors its commitments. Germany will share intelligence if alliance partners prove reliable. The Netherlands will process subpoenas if treaties remain mutually beneficial. Every relationship has an if, every cooperation has a condition, and conditions can always be renegotiated. The rule of law is supposed to be unconditional. You break the law, you face consequences. Full stop. No diplomatic calculation, no foreign policy consideration.